Hi, students. I owe you a lecture, or at least a completion of a lecture on organizing your oral argument. When we last met and we talked about oral arguments, I showed everyone different video clips. I'm going to be sending you an email with more sample clips so you can watch them at your leisure. But in the meantime, I want you to get a sense for what you need to prepare since your oral arguments will be held this week. So I'm going to share my screen so you can see it. And you don't really need to see me, so I'm gonna go ahead and turn my video off as I talk to you about oral arguments and how to organize them. Excuse me. Okay, so you want to, this is actually where we left off during our last class. You want to figure out what your main points are. What are your takeaways in terms of why you should win? CREAC still matters, but it's a very modified CREAC. Your conclusion should be focused on what's the bottom line? What do you want the court to do? We are asking the court, reverse the judgment of the lower court or affirm. Make sure you spit that out early. What rules of law are you relying upon? You don't have to worry about rule explanation because that should have been done in your brief, but you're really talking about your analysis and your argument more than anything. You're not going to be doing a bunch of case comparisons. If you do, it'll be just one case that you mentioned that's a really great case, but it's not going to really look like your brief. So in terms of your argument, you want to, when you talk about cases, focus on the reasoning, not the details. Get to the point. What is the heart of the issues? And make sure you are able to have specific support for your argument. So if one of the judges asks if you have any precedent or can you give an example, make sure you're prepared for that. I think I spoke on this during last class, but I want to slow it down a little bit because I know it was towards the end. There are basically two different ways that judges can conduct their oral arguments. One would be the cold bench. A cold bench is where you're not really asked many questions at all, where you're able to give a true opening statement and remarks and present some of your argument uninterrupted. If you are going to be arguing before a cold bench, you want an expanded outline so you have something to say. The other type is a hot bench. That is where you're going to be interrupted a lot. And in that case, you want to know what your main points are. If you only had a few minutes to get out this main talking point, what would that talking point or those points be? That's what you really want to focus on. Now, what kind of bench am I going to be? It depends. And I talked about that during the last class as well. So we showed you a clip, or I showed you a clip of the Ashcroft case. And as I said earlier, instead of just showing it to you on the computer, I'm going to just send you guys links. But it was quite a fascinating case. But I want to talk to you about preparing, because that's the point of today's lecture, this recording. You want to practice. What do I mean by practice your argument? I always practice, whether I was giving a statement or arguing summary judgment before a federal judge or my voir dire before a jury or my opening or closing statement, whatever it is that you're going to do, you want to be so familiar with it that you're able to speak on it with confidence, right? So I think when it comes to oral arguments, you need to always know what your opening remarks are going to be, what your last words are going to be, because you want to start strong and end strong, and what kind of things you want to touch on in your rebuttal. Of course, your rebuttal needs to be tailored to whatever the other side says. Of course, both of you will not have a rebuttal. So make sure you're not just reading the brief or your argument or your notes. Don't memorize the body, because people who memorize speeches or whole arguments, they tend to get upset when they're interrupted. And they usually show their displeasure in all kinds of ways. And that's not what you should do, because remember, the point of an oral argument is actually to be available and to make yourself available for questions. You can practice, obviously, in the mirror, in front of friends, visit the courtroom. All right, let me pause for just a moment. So the importance of not reading is so important that the United States Supreme Court has a rule about it. Do not read is not favored. That's a bad, bad thing to do. Judge Williams said the worst thing you can do is deliver a stiff presentation by attempting to read your argument verbatim. Such a presentation style is tedious, makes it difficult for you to answer questions from the bench. You're likely to miss signals from the bench, and you cannot engage in a dialogue with the judges. So what do you need to do? In the very beginning, I'm going to say the docket number, and I need, if you're not already standing, everyone raise to your feet, because you have to rise to your feet to address the court, and say you're ready. And I'm going to say you may begin. I'm going to want the person who's presenting the motion, the appellant, to come forward and say, may it please the court. What's your name? Who do you represent? Do you have co-counsel? Why are you here? What do you want? May it please the court, my name is Najri Rutledge, and I, along with my co-counsel Cheryl Lewis, represent appellant John Doe. And you should also say, before I begin, I would like to request 1 minute, 2 minutes for rebuttal. It should not, by any stretch of the imagination, I think 2 minutes is plenty for rebuttal. 3 minutes is pushing it. So petitioner, that's the appellant, let the judge know how much time you're reserving for rebuttal, if any. If you forget, you're not getting it. You do not get to, in the middle of your oral argument, say, oh yeah, I need rebuttal. Denied. Once you request rebuttal time, wait for the judge to grant the request. Then you may start arguing and the clock will begin. State what you want the court to do, reverse or affirm, what the issue is. Say that there are 2 reasons, 3 reasons, whatever. The court should rule in your favor. Be able to state each reason in 1 sentence and give those relevant facts. Appellee, the respondent, you should go to the podium as soon as the other counsel leaves. Do not wait for me to say, okay, you can get up now. Just get up, you know it's your turn. Introduce yourself and the client. You do not have rebuttal time. So now that we know that we all start with may it please the court, my name is, who you represent, what you want. Give the court a preview. This is your roadmap. What are your 2 to 3 main points? Those points you need to memorize. Now, when I have an outline or notes, I actually, if I'm interrupted with a question, I'll put a check mark at the point that I was going to make so I can address the question. And if I'm nervous or what have you, I can go right back to my notes to know where to pick up where I left off. At the end of all of that, you want to try to conclude by ending gracefully and persuasively. What are your best or strongest points? Start with your conclusion. As soon as I say you've got 1 minute, you need to start figuring out how to dovetail to the conclusion. If you're out of time, you can finish, stop, say thank you, sit down. If you're in the middle of a question, then you can ask permission to finish. I see my time is up. May I finish answering the question? If I say no, stop and sit down. Whatever you do, do not overtalk the judge. Again, do not overtalk the judge. When my mouth opens, yours should shut. So I told you about rebuttal. Let's get into a little bit more of the details. The most important thing you can do if you get the privilege of a rebuttal is to listen. Listen closely to what the appellee is saying. Do they have any weak points? Are there any points that hurt you? Or even better, are there any points that they were stuck on and you can piggyback on? Let's say that they inartfully messed up a question the court asked, and you know you can somehow shove that right back down their throat because you got a better answer. That is exactly where I would start with for my rebuttal. Your goal in rebuttal ultimately is to try to make your points, but you really don't want to engage in a back and forth because then I'm going to eat up all your rebuttal time. So I'm going to send you the link to Everett v. State of Florida. I think it's a good case. I think there's a death penalty case, but it's a very interesting case to look at as well. Campbell v. State is another good case. This is a cold bench, so the litigants in that case had an opportunity to really talk quite a bit. And then we have an example of a hot bench with Perry v. Schwarzenegger. Fascinating case. In this case, the court was even a bit hostile, and sadly, sometimes that's going to happen. But we're not going to look at it, as tempting as it is. I want you to look at it on your own. because I'm going to focus on just giving you some tips. Now, in terms of Justice Roberts' on questions, let's see, I bet it's not even going to play. If it plays, I'll let it play because it's just a 2-minute clip.
Do you remember your first oral argument?
Oh, sure, yes, absolutely. A case called United States against Halper. I was very nervous, but I was very nervous when I did my last oral argument as well. I think if you're a lawyer appearing before the Supreme Court and you're not very nervous, you don't really understand what's going on.
This is a question for all the members of the bar out there, I guess, and for all those attorneys who eventually find themselves lucky enough to have a case before the court. What is it that you wish you had known about the process when you were on that side that you now know?
Everybody tells a lawyer in that position, you have to answer the questions. Don't try to avoid the questions or distinguish your case in any way. I hope I did that when I was a lawyer, but the importance of that is very accentuated. I appreciate it so much more now that I'm on the other side of the bench. You have to appreciate that the justices are engaged in the process of trying to help themselves decide the case correctly. So they're going to ask hard questions. They're going to ask questions that don't put your case in the best possible light, and you need to appreciate that. It's good to establish, and I think I didn't appreciate this as much as I should have, some dispassion. Yes, you want to have a certain level of zeal and commitment to your client's cause. The justices know that. But when they ask you a question about a difficult case, it's better to sometimes say, I appreciate that that case doesn't support my side. I appreciate that that causes us some difficulty. Here's why I think you shouldn't rely so heavily on that case, as opposed to as soon as they ask us, no, that case doesn't hurt us at all, and here's why. They like you to be part of the process that is helping them come to the right result. They understand you've got a client to represent, and they expect you to do that. But if you can convince them that you're on their side in helping them reach the right decision, as opposed to something they have to push against to get you to give an answer, I think that's very helpful, not only to the court, but also to your client.
It was, of course, helpful, Justice Roberts. So remember I told you in the beginning of the semester that this is going to be an opportunity to answer questions. That's what an oral argument is for. It's not for making speeches, but it's an opportunity for you to answer questions. So you need to anticipate those questions and you need to welcome them. Questions may even begin before you're done with your opening remarks. Think about in your preparation, what would you ask if you were a judge? What key cases will concern the court? Be prepared for a question before you finish summarizing your arguments. If you're interrupted, stop talking. Listen carefully. Answer the question posed. Don't try to evade it. If the question was unclear, politely ask for clarification. Take your time. Make sure you completely understand the question. Notice I paused there. Silence and taking a moment to gather your thoughts is not a sign of weakness. It's sometimes much better than trying to find space fillers like or fumbling around. Never interrupt the judges. They hate that, even if they interrupt you. I've said it once, I'll say it again and again. When a judge starts talking, you should stop. Don't fight the judges. You will never win that fight. Be persuasive without being pushy. Try not to rush through your answer to get back to your notes, because the whole reason you're there is to be available for their questions. Don't get defensive because they've interrupted you. Never interrupt the judge. Never, and this happened to me one time in an oral argument, never answer the question then or say, I'll get to that. No, you're going to get to it when I ask you the question, period. Try to maintain your composure. Now, what happens if there's a question that is posed and you don't know the answer? Well, don't make it up. It's okay to say you don't know, and you can offer to provide information after the argument. I remember I asked a very simple question about a statute that was one of the most important statutes involved in the student's briefs. And the student had no idea what I was talking about. Well, it wouldn't have done me any good to berate the student right there. I was very gracious. And the student said, I'm not familiar with that, but I'll be happy to, and who knows, maybe they just had a moment where they got scared. But whatever it is, you can recover. Just admit, I'm not familiar with that case or that statute, but if I will provide the court with an answer with a supplemental brief, if you will allow. After your questions, if you pause and wait for another question, you will get another question or 2 or 3 or 4. Instead, return to your argument. Don't wait for permission to restart. It's not happening. Don't wait for the judge to respond. That's not happening. Just go back to your argument, which is why making a little mark like a check mark in your outline where you left off is a good idea. Always refer to the court as the court, your honor, justice, or judge. There are some judges, and particularly some female judges, who take true offense to being called ma'am. They are a judge, they are your honor. Opposing counsel, you can call them opposing counsel or counsel for appellant or appellee. This is not personal. I don't want to hear anyone's first name. Now, what about my students who are nervous, who hate public speaking, who are scared to death? So one of the favorite things I like to hear is do it afraid. You want to try to capitalize on nervous energy because that's what nerves and butterflies really are. It's just raw energy. Do your best. And remember, everyone has to start somewhere. All of you probably remember my story in law school where I completely froze and freaked out during my oral argument and had absolutely nothing to say. No matter what, you will not be that bad. In terms of your oral argument and some basics of public speaking, eye contact matters. Connection matters. Whether you're giving a speech or teaching a class or doing an oral argument or trying to convince a judge. If there's more than one judge, try to have some eye contact with all of them. Don't look around to the sky. I have a habit of this, like you're going to somehow find the answer in your brain or look down at your notes. Have that eye contact, make that connection. Now, in the end, the court is much more interested in the law and the facts than your oratorical style. There are some people who are great speakers who just really aren't the best lawyers. Know the law, know the facts, and you'll be fine. In the end, I mainly care about your preparation. Speak loudly. Don't make me have to say, speak up, I can't hear you. Don't mumble, blah, 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 blah. Don't be monotone. That is so painful to listen to. Vocal variety. Figure out what points in the argument you want to speed up, you want to emphasize, what have you. It's a good idea to stand behind the podium and avoid distracting gestures. So your nonverbal reactions can be a problem. Be careful. What is a distracting gesture? Leave the pen at the desk. Do not even take your pen up there unless you know how to make a little bitty check mark on your paper if you're interrupted and put the pen down. But if you have a tendency to wave, to point, to click, to chew on that pen or pencil, don't take it up there with you. If you are someone who likes to twirl their hair, toss their hair, finger their hair, just, put your hand through your waves, don't do it. Put it in a ponytail, put it up, put enough gel on it where you don't want to touch it, but leave your hair alone. Leave your keys at home. Jingling keys is distracting, irritating, unprofessional. Watch your body language. Never react to the judge or opposing counsel in a way that would be seen as disrespectful or passive aggressive. Number one way, the eye roll. Okay, you're not a moody teenager. No big exhales, deep sighs, no shaking, nodding heads, no squirming in your seat, putting your head on the desk, throwing a pen or pencil down on the table. I saw this one time when I was a prosecutor. Poor baby prosecutor was having her first trial. I was her chief sitting with her, and the judge overruled her. And she was so frustrated. I think she may have stomped her foot too, but she threw that pen on the table and all hell broke loose because the judge was not having it. Called the DA. No, not the assistant, the DA to complain. And that was just an ugly situation. So make sure you watch your nonverbal reactions. Now, what happens if it's not really your fault? You just have a judge who is difficult. And sadly, sometime in your career, this may happen to you, where you just have a judge who is just really, really Evel Knievel difficult. Even when they're difficult, always be respectful. And I'm just going to quote Michelle Obama here. When they go low, you go high. Focus on the question, never the packaging of the question. I have students do that all the time. They'll, get all puffed up about something. They upset, they in the feelings, and they'll say something with a really nasty tone of voice. Now, I tend to not just, snap back at my students. I've done it, but I try not to do it. I try instead to, thinking about how disrespectful they're being, I think about, okay, forget that. What are they actually asking? What are they worried about? What's concerning them? And that's why I try to go to. I need you to do the same thing, even if the judge is really difficult. Now, I do not anticipate you're going to have any difficult judges during your oral arguments. I'm very careful to have judges, guest judges, who are concerned with you getting better, being better as a student. Okay, so you don't have to worry about that, but I'm really talking more about practice. If someone keeps trying to get you to agree to something, it's okay to say no. I must respectfully disagree. Or yes, Your Honor, that is sometimes the case, but not always. Now, the oral argument tends to be 6 to 10 minutes per side. You cannot have 10 minutes, as we just will not keep on track with that. My goal will be 6 to 7 minutes each side. And then the rest of the time will be me giving you feedback. Try to look professional. Don't go shopping, but look professional. Steam or iron your clothes. Don't come in with wrinkled clothing. Don't come with anything you would wear to a club. I'm bringing guests that are practicing right now. Do not embarrass me or yourself in front of our alumni. Make sure that you, at this moment, when you see the judges, you make sure you address them as Your Honor or Judge so-and-so. So that's it. We already did the brief thing. I don't have anything else. I'm going to stop the share. And normally I would say if there are any questions, but of course there are, I can't answer questions through video, but I am always available. You guys should know that. You have my cell number. You have my email. You can text, you can send an email, you can even call me. If you have any questions at all, I'm happy to assist you. This should be a fun process. Have fun with it. Okay, it's only 5% of your grade, and as long as you prepare, I don't care who's the best speaker. So have fun, try not to be nervous, and it will be over before you know it, because every single student who's ever done oral argument says the same thing to me. Oh my God, that went by so fast. It's going to go by really fast. My questions will be fair. I'm not trying to stump anyone. I'm really just trying to get at your preparation, get a sense for what you're asking. I will not be looking at anyone's brief before the oral argument. So don't think that I'm questioning you about your specific brief. So that is it. I hope this was helpful. And in the email where I send the link to this video, I'll also send the links to those other oral arguments. Thank you for listening.